on a Saturday. We have some folks on Zoom as well today, so at a point we'll have questions and answers, and you all be aware that you can ask questions as well as expect questions from the audience on Zoom, all right? So today we're going to proceed in 4 parts. This is going to be extremely informal, so it is not like school. First of all, I'm going to do an overview of the book series. Then we're going to get into a little bit of a discussion about book 1, which is under indictment. That is this book. And when you arrived, you were asked to give an address. The reason for that is that Southern University Law Center will be mailing you a copy. If you gave them an address, you will get a copy in the mail. So be sure that you leave your address outside if you didn't do that already, because you'll be getting a copy in the mail. After we briefly discuss book 1, we're going to jump to book 3, and we're going to talk a little bit about it, and that is the summons. And you may be wondering, why is it that we're skipping book 2? And the reason is book 2 focuses a lot on diversity, and we're having a diversity week event in March, and that book will be the focus of the March event. So if you have signed up, you'll be getting invited to come back for the March discussion of diversity. And then lastly, there'll be some time in the program for questions and answers, or just comments if you want to share any. So I'm going to go ahead and start by telling you that it was about 27 years ago that I left law school. I was a student here at Southern University, and I had this amazing optimism when I left law school about the legal profession and about all of the things that I was going to be doing as a lawyer in order to achieve justice for folks. I went to work for the first 10 years, not as a private practitioner, but I worked inside the judicial branch. And it did not take me long to realize inside the walls of a judiciary that law school and actual practice was not connected. There was a gap somehow between those two facilities that I was working in and the institution that trained me, particularly when it came to criminal law. The weight of what I started to witness being inside of a judicial chamber became just way too much for me. And I ultimately left to come to an academic setting because, one, I no longer wanted to have agency in any system that I felt to be harmful. 2, I wanted to be sure that wherever I could be, I would elevate the voices and the experiences of people who the law profession and the legal academy had rendered unheard, people who had gone unnoticed. And so I came to law school and have now become what many describe as an academic activist scholar. I'm also, in addition to an activist scholar, an expert on the interplay between race and law. And so now we fast forward, it is nearly 30 years later. And what I see now that I have done with all of this passion and disappointment and frustration and curiosity and concern is really innovated a pathway now for lawyers who want to do the work of social justice lawyering. And so how do I do that? I ultimately place restorative justice and transitional justice at the center of everything I do. And my work in ending non-unanimous juries is just one example of how I've been able to sort of formulate this legal cocktail that I described to you today. So I want to talk to you about what this work in ending non-unanimous juries look like. First of all, I don't want to assume we know what a non-unanimous jury is, so I'll talk briefly about what that is. And what that means is that you will have in Louisiana 12 people sitting in the jury box, which is pretty traditional around the country. But Louisiana and Oregon for many, many years had a practice of saying to the 12 folks in the jury box, 1 or 2 of you can have reasonable doubt. We just won't consider it. So you can cast reasonable doubt, but we'll ignore you. And so our system would allow 10 of those 12 people to make a decision about guilt or innocence, or maybe 11. So what we call non-unanimous juries is really meaning that the vote to convict somebody was not unanimous. There was at least 10 people who felt you were guilty, and at least 1 or 2 who said no, maybe not. All right. So that system sounds pretty generic. It's just a rule in law. But in 2018, 64% of Louisiana voters went to the polls and registered their firm objection to having such a system, and those non-unanimous juries came to an end in Louisiana and ultimately in Oregon, which is the second state that used these non-unanimous juries. So once it's over, I exhale. And in 2019, I decide that I really want to write a book to help people understand this work that I described, this restorative justice and this transitional justice and this law degree, and how do I merge all this stuff to work on these campaigns that actually change history. So as I start writing that book, I begin getting letters in the mail. And my hope for the book was to profile these people behind the scenes who did this incredible work, but the world never gave them their place in history. And when I talk to you about these anonymous folks, I mean two Black men, Calvin Duncan being one, and Calvin Duncan himself is a book, but Calvin Duncan, at the time that we learn his story, he's actually in Angola. Calvin Duncan is serving a life sentence in Angola. He's the typical profile of who you see in Angola. He's a Black man, no father. His mother died when he was young, and he was the perfect victim for prosecutors to call a criminal. And so Calvin Duncan, from behind those walls in Angola, is burdened with these non-unanimous juries, and he starts that work inside. Calvin Duncan leaves Angola and could say, now that I'm free, Innocence Project has declared me an exoneree, I'm done with the law. But instead, Calvin Duncan just decides in freedom to continue the fight he started behind bars. This Calvin Duncan I speak of at the time, I said to you, was incarcerated and then soon became free and went to work on these non-unanimous juries. But while we were doing this work, Calvin Duncan had a desire to do more in the legal profession. The profession that actually took his freedom for over 28 years, Calvin Duncan decides to enroll in Tulane. He becomes a paralegal, and today Calvin Duncan is now a lawyer. But this is somebody who no one has recognized for doing this tremendous work. And it was important to me when I started writing the book to help the world understand that these narratives that you see about Black men and them being predators and them wanting to hurt people, there's a counter narrative like Calvin Duncan. He motivated the book. There's also Will Snowden, who is now a professor at Loyola in New Orleans. But Will Snowden, before any of us started talking about non-unanimous juries, was walking around with this project called the Juror Project and going into barbershops on Saturday mornings and talking to people of color about why they need to be sitting in the jury box. So the world never recognized Will Snowden for what he did. And so those were my motivations when I started writing the book, to tell the world about these two Black men, to tell the world about this Black woman who at this point I had been recorded in only one book before these. That book came about after years of me devoting my life to another piece of tremendous Louisiana history. It is the fight for the Angola Three's release. Those men have been held in solitary confinement, one of them over 41 years, the other over 42 years. When the book gets written, it is interesting that the white female author decides, when she decides to tell the story about Professor Bell, she doesn't mention that Professor Bell sat in the halls of Congress and gave testimony. She doesn't mention that Professor Bell was speaking in Russia and France, and Professor Bell wrote articles. What she did tell the world in the book is that Professor Bell got up and brought food into the prison. The historical narrative about Black women were domestic workers. That's all we're capable of. And so I knew when I wrote this book that if truth would be told, I would have to be the truth teller. So that would be my motivation when I started the books. But I also wanted to inspire people, the many people who ask me, how do you do this stuff? How do you do the work of social change? I wanted to give them an answer, how to do it legally, how to do it morally. And so I wanted to write a book to explain the advocacy work that we did in the world that I've discovered as an advocate, so that we can engage in social change that is legal. And so when I started writing the book with all of these aims, I started getting letters from lawyers. And the letters and the emails started saying, Professor Bell, do you all know that you did all of this work to get these 9 unanimous juries. And now, yeah, we have them. We have 12, but there's a problem. There's still all white folks in the jury box. We don't have any diversity. And I'm not bothered by that because I don't like white folks. That's not the point. The point is there is a body of science that tells us that if you really want a reliable and an accurate outcome at a trial, the best way to get that is to ensure there is diversity in that jury box. And I'm not speaking of diversity by race. I'm speaking of diversity by experience. I'm talking about diversity by thought. I'm talking about you being older and having wise thoughts about things, and me being younger and me having the energy and the fire that you lack as an elder, and us putting that together in a conversation. I'm talking about somebody white who has a different experience with law enforcement than somebody Black. And I'm talking about somebody from a different country and somebody from this country. And when we put all those discussions together, what happens according to the science is the process slows down just a little. The science tells us that somebody's memory in that group is going to be better than somebody else's. And so in the process of us deliberating, somebody's going to correct mistakes the other made. Somebody's going to be able to point out things that the other didn't see. Somebody's going to interject their experiences in that process. So then at the end, we have a richer and more reliable outcome. So the frustration when I started writing the book is that we did this because we thought we were going to end this struggle for jury justice in Louisiana, but the struggle just changes form. So then I had to step back and ask, why is it so difficult? Why is it so difficult? Why is Louisiana so resistant to allowing people of color into this space, this precious space, this jury box? And why is it that people of color don't understand the need to be there? So I had to pivot, and the book sort of changed from what it originally was supposed to be to a deeper dive into understanding this boat, this chain that was placed on the jury box, and understanding why it is. So then that quest for an answer led to not a book, but 3 books. And so I begin here with just a few pages from the introduction. And if you have the book, I'm on pages 2 through 4. And I want to just quote this text to you from this introduction so you can feel sort of where I'm at when I'm starting the book. But I begin, and this is a quote: "Today I see law for what it is and not what I had hoped our years together to be. Law has been unfaithful. Law has been abusive. Law has been inconsistent, and it has been very deceptive. At intervals, law, in fact, has been a friend. Sometimes law has even been a remedy. Law sometimes is a solution, but often law is power. In an instance, law is trauma. Law sometimes is an opponent. Law becomes an ally on some days. Some situations, law is hypocritical. Law is frequently violent. Law can be a weapon. In fact, it can be a dangerous weapon. And this book is an act of resistance," I go on to say. "This book punctuates the sentences by the Maroons, the sentences that they never got to finish because they were killed during chattel slavery. They were killed for no good reason. They were killed simply because they refused to go alone. I join those Maroons in refusing to go alone. I join those Maroons in demanding another way, a better way. As an activist scholar, I do not write to fill my resume with publications or presentations or with a craving to attain promotion. I write to cause revolutions, and I confess the same in these books. So what do I mean, you wonder, by revolution? I simply mean a radical change in the established order. So what kind of revolution do I hope to see with this book series? I want to see the legal system stop harming and inflicting violence on people. I want to see all players in the legal system refuse to be agents in any act or decision or process that harms or inflicts violence. I want to see people no longer abuse power. I want to see us understand the jury. I want us to understand that legal education has to be completely reimagined. so that the experiences and the struggles of marginalized people are included in the way lawyers are trained. I want to see a legal system in Louisiana that is totally transitioned. So there is no bias. There is no supremacy, no racism, no racial hierarchies. I want to see speed and capitalism, all of that extracted out of our legal system. I want to see citizens accept a partnership in this transition process. So I briefly want to tell you that these books also have dedications that mean a lot to me, and I hope they become important to you. So I want to talk to you about the first. This first book is dedicated to a woman named Aretha Castle Haley, who I met when I was 16. Aretha Castle Haley, I describe in the book, was a hurricane to folks in Louisiana who didn't like justice. But I go on in the book to explain that she was not a hurricane, she was a Category 5. Anybody that did not like justice was never comfortable around Aretha Castle Haley, and that is important that you remember that name. The second book here is dedicated to the Maroons, who I spoke of earlier. These were people in chattel slavery who said, I don't have any internet, I don't have any resources, I don't have a way to collaborate with folks, but I know one thing, I won't be complicit in my own oppression. And they simply just walked off plantations. And when they did that, they were so effective that they disrupted an entire economy, to the point where the governor of Louisiana said, look, we have to end these Maroons because there's such a successful threat to chattel slavery. And this last book here, The Summons, I dedicate to the 14-year-old Black girl who was taken from her home in Africa, put aboard a ship, raped repeatedly, infected with gonorrhea, and then told to dance. And this 14-year-old Black girl said, no, I won't. She was beaten, she was maimed, and she died. And it's important that you understand all of these people that I mentioned are just ordinary folks, don't have any law degrees, don't have any type of pedigree, but they started revolution. They disrupted a system that was harmful, and that is the reason that they were specifically chosen. So now I want to talk to you a little bit about the specifics of book one. Book one, I'm on page 26, if you have a book, says in order to really understand this long journey for jury justice, let's really go back and understand the first time a person of color set foot in Louisiana. So book one around page 26 takes us back to the 1700s. And something immediately comes out in that research, and that is that in the 1700s, this time in Louisiana's history, we don't really have an organized rule of law. It just doesn't exist. We do have some rules, but there's no order, they're here and there. But then by the 1800s, the notion of the rule of law starts to really come alive. 1805 is a defining moment in Louisiana's history because it's at that point that we get something called the Crimes Act of 1805. That Crime Act says that there's now an official way to punish people. So we set out our crimes, what it is you cannot do, and what the sentence is if you do it. And it gives the sense that we are now starting a very organized civil law legal system. The problem with this is that nothing in the Crimes Act of 1805 applied to people of color. What did apply to people of color is by 1806, we get a Black code. And guess what happens? That Black code has different laws, that Black code has different penalties. And so we can immediately see from the time that first Black person gets here, we have developed a system where we will have rules, but the rules will never be consistent. There will be rules for you, there will be expectations for you, there will be punishments for you, and there will be punishments from us. Now, there are many of you who will argue that that is no longer the way we practice law. The book challenges you to see that it is really, truly the way we still practice law, although we don't physically have those two books anymore. But we physically do have the notion that there is not a unified approach to administering justice in the state of Louisiana. It's important also to know, in addition to having this Black code, we had a system because the code is the rules, right? But I want to talk about the process. What's the process? There was two ways that we would administer justice to people of color at this point. One is what I call in the book plantation justice, which is you have only one purpose, person of color, which is to be somebody's labor agent. So I'm here just to work. I'm somebody's to be exploiting my labor. That's your only purpose. So I need to quickly deal with your behavior to get you back to work, right? So on that plantation, I'm going to punish you and you're going to go back to work. That was one way we would handle things. For the more serious transgressors, we did something called these tribunals. The book speaks a lot about the tribunals back in the 1800s. So what is a tribunal? It is one person who is going to make a decision. That one person is likely going to be a slave master, and you are likely the enslaved. And that tribunal is going to say to you what it is you're accused of. That tribunal is going to say that you have 24 hours to defend yourself, and that tribunal is going to impose justice. Now, I am describing the process that was afforded to a person of color in the 1800s. It was swift, it was biased, it was unjust. Now, pause and process. By the time I get to the end of the book, what I describe in 2025 is just like what I just represented to you to be the slave tribunals in the 1800s. It is swift, it is lacking of any true measure of justice, and there is really no process. It is a sham. So we have really come nowhere. We have taken no journey forward when we think about where we started and where we end up today. Now, the next thing that I talked to you about in the book here is that the Civil War happens to come about, and many people say, and I'm talking around page 41 here, that when the Civil War happens, this is now a change from where it used to be to where it now will be reconstructed. So the book says, let's really think that through. We do have a Civil War, and of course, history will tell us that Louisiana and the Confederates lost. The book argues that that is really not true. So this book attempts to teach us a little bit better that I don't believe that that is true, that we lost the Civil War, and I'll explain to you why. When the Civil War ended, it was not because the South or the Confederacy said, you know what, federal government, you're right. We were completely wrong for human trafficking. We were wrong for our supremacist thoughts. We're not going to treat people like they're less than us anymore. That is really not how this ended. This ended because there was more manpower. The mindset never, ever, ever surrendered. So what the book successfully points out is after a Civil War, now you think about this, these are a group of people who say, I'm going to talk to you, federal government, and put you in check, federal government. I'm going to tell the federal government how this goes. And if you don't listen to me, I'm going to actually take up arms and fight the federal government. Now, once you supposedly lost, the average person would think you'd be going hide, right? You would bury yourself somewhere because you're so ashamed of what you did. But what the book says is it's not at all what happened. The book talks to you about how these Confederates simply said, okay, change uniform. Take that Confederate battle uniform off. Confederate war now, we're going to fight it on a completely different battlefield. So I fight it now in judicial chambers. I'm a judge, former Confederate. I fight it now in the legislature. I'm writing laws, former Confederate. I fight it as an academic. I fight it now as one of your leaders in government, a government official. So all of these former Confederates did something radically different after the Civil War than any of us would have anticipated. They didn't have a change of heart. They didn't feel embarrassed. They were celebrated. In fact, the book describes one scene. It was like Prince was on the stage, right? When one of these Civil War battlefield generals comes out after the Civil War, people are celebrating these people. So what they now understand is that there is a following in the South. You know, it's like, I want you all to think about this, translate this. You ever seen these guys who people say they actually are middle-class guy, but they trying to walk around like they some kind of thug, right? Why they want to get arrested? Why do they want to get a police report? Because it makes everybody around them start thinking, you know, they bad, right? It gets me a following. Well, that's how these people were with the Civil War. Now I'm bad, I'm hood because I just stood up to the government. So when they get back down here in Louisiana and they writing rules, they are in power and they don't do anything to apologize for what they thought was supposed to continue to be the norms. This is an important thing, and the book seizes upon one moment to tie this history to criminal justice. And it tells the story about one of those former Confederate generals who looks around after the Civil War and says, now, all of my precious land is gone, just been destroyed, right? The war tore it all apart. I don't have anything. But the notion in these people's minds that they would go out and cut their grass or they would take care of their own plantations, it just could not be conceived of. They could not see themselves as doing labor. So their immediate thought was, how do I get their free labor back? What do I need to do to get these people back to work to clean this mess up after the Civil War? So here's this one former Confederate general who says to Louisiana's legislature, this is just a man who's unemployed now, goes over to the legislature and says, you know what? All of these people that you released, they don't have anywhere to go all day. They're just lingering around. It's not okay that they just linger around. We go to work, we own stuff, right? We're taking care of our property. We need to get a law in the books that's gonna arrest them for just lingering. So guess what the law becomes? Vagrancy. And we don't want to just charge them something small like a misdemeanor for being vagrants. Now imagine if you just got released in 1865 when chattel slavery ends, what else are you going to be doing, by the way? Because you don't have a job, you don't have a house, you have nothing. But when they wrote the vagrancy law, they put this clause in the sentencing that this is going to be a hard labor offense, okay? So now imagine all of these people who are arrested under this vagrancy law, they are now being taken into custody. Well, Louisiana has a new problem because remember I said to you before this, we always dealt with justice on plantations, hurry up, get back to work. We have always had prisons, don't get me wrong, but we didn't have a need to mass incarcerate because we wanted those Black folks to be working. So now we have a problem. So this one Confederate general who has aided us in fashioning the law says, I'm gonna aid you with the solution. So here's the solution. You give them to me, I will lease them out, I'll put them to work, I'll get some money out of this transaction and gets them off the street, everybody wins. So now this guy takes his former plantations, takes all of these people arrested with vagrancy, sends them to work. So does it sound like a shift in what was happening already? Because remember, they were already working on plantations and the law said you're now free, but now in freedom, they're back on these plantations. But what's important about the story is the way the law was used to free people and then oppress people. Yes. What's important about the story is who engineered the law and who engineered the system and who taught us about this thing called policy that we now need to deal with. This Confederate general that I've spoken about anonymously has a name. His name is Major Samuel James, and his property that I speak about is Angola. So this mass incarceration system that we know in Louisiana, we are really celebrating every time we send somebody to Angola, this former Confederate general who really was a mastermind at figuring out, how do I get my plantations to be profitable again after the Civil War, okay? So that now begins our relationship, people of color, with the justice system after the Civil War. So Samuel James, who should have been embarrassed, is now a celebrity because he is known to the legislature as this brilliant visionary. He's rich now, he's making money, he's interested in maintaining. One of those other former Confederate generals rises to the ranks to become not just a Louisiana judge, not just a Louisiana Supreme Court judge, but a US Supreme Court judge. So the book tells a story about how E.D. White was able to sit on the bench and stop people from voting. And so he successfully fought the Civil War in a Supreme Court justice role. Please process, the war never stopped. And so the book tells us that the war was fought, it was just fought on different battlefields. And nobody has really done this journey back in history to connect the dots. So when we talk about a jury and we talk about a resistance to allowing people on the jury, what I hope to help you understand is this. The jury box is not just a place where you go to make a decision. It's not just a random group of folks who are sitting to talk. When you get in the jury box, for that moment in time, you are no longer just a citizen. you have the power of an elected official because you are sitting with decisions that no one else can make. You are sitting and with the stroke of a pen, you can take somebody's freedom. That is an enormous power. And so what was understood during Reconstruction is, do we really want, when we say freedom, and the book talks a lot about this, when we really say freedom, do we really mean that? Do we mean all of that power, or do we mean freedom just to get off the plantation? And so one of the things chapter 1 helps us understand is that one of the obstacles with us being in that jury box is the notion of freedom back during Reconstruction, when that Reconstruction Congress enacted the 13th Amendment, was never truly settled. Now that's shocking because we've walked around all of our adult lives thinking we're free, thinking there's a 13th Amendment. But the problem is, if you read the Reconstruction record, there were some folks who said, and in those debates, freedom means end chattel slavery and let them go. Literal movement, right? There were other people in those debates that said, no, that's really not freedom. That's just movement. Freedom is really power. Freedom is the ability to change what you don't like. Freedom is to be able to be in the democracy and call the rules and cast a vote and serve in public office. So they said, wait a minute, that's not what we had in mind when we started talking about the 13th Amendment. So they're fighting about really what is freedom. Somebody stands up in the room, and all of this is discussed in the book, and says, well, wait a minute, when you say freedom, do you mean free like as in a Black man being able to do what other Black men do? Because that's one conversation. Or do you mean a Black man doing what white men do? Because that's a whole different conversation. So then they are back and forth. Well, do you mean freedom as in children are free too? So nobody really understood what they were agreeing to when they wrote the 13th Amendment. So they basically just said, okay, this is what we're gonna do. You just leave the plantation. But chapter 2 specifically says, now you have to understand how you remain locked into this relationship with injustice, because chapter 2 is all about political rights. So political rights mean the right to hold a public office, the right to cast a vote, the right to sit on a jury. And what I argue in chapter 2 is that political rights are way, way more important to a person than civil rights. Because if you have all of the right to sign a contract, make decisions, but you don't have any right to have any change in society, to affect change, to do anything, to cast a vote, to decide who's going to go to jail, who's not, you really are not equal. So political rights was the way that this reconstructed Congress ended up holding us to some form of slavery, which in the book I call neo-slavery, right? So we are in neo-slavery, and the book goes on to say, if you don't believe me, let's just study each political right. So there's a long section in chapter 2 that talks about the fight in Louisiana just to become a judge of color, just to become a judge, just to sit on the city council, just to be able to hold a public office. So when you see that fight, and the fight, by the way, didn't go from 1800s to 1800s, the fight goes from 1800s to 2025, still going on, because there has never been a decision on the part of this government to make sure that there were both civil and political rights given to people of color. The book says, okay, if you're not convinced after you hear about elected officials, let's talk about the vote. And so the book goes on to show how many ways we have fashioned schemes to stop people of color from voting. Why? Because when you cast a vote, you're exercising power. When you cast a vote, you're playing in the democracy. When you cast a vote, you can actually change what you don't like. So that has been a way to keep us in this bondage, this neo-slavery. So that book talks now, if you understand how difficult it's been to hold office, you understand how difficult it's been to cast a vote, imagine when you talk about sitting on a jury, what that's going to be like. So that book goes into this whole struggle for jury justice, starting in the 1800s, when we first get our Civil Rights Act that supposedly makes it illegal for you to stop somebody from sitting on a jury. The book talks about 1800, when you have a man that the world knows as Homer Plessy's lawyer, Louis A. Martinet. The world is not aware, though, that Martinet was not just interested in Homer Plessy. Martinet's fight in his lifetime was to end segregation. And so Martinet devoted a large part of his life to what he called the Jim Crow jury. So what is happening in the 1800s? Martinet and Homer Plessy and the Citizens Committee are writing letters up to the United States Congress saying, United States Congress, we are 10 years removed, 20 years removed from emancipation, and we still have no freedom here in Louisiana. We still can't participate in juries. They're locking us out of the jury box. So we're watching all of our people be taken into custody and overcharged, and we can't do anything about it. And everything I'm reading in those minutes from the Citizens Committee, here's Louis A. Martinet, who looks like a white man, This is amazing to me that this man who, by the way, December of 2024, I find myself out on Canal Street in New Orleans. So if you ever go near Popeyes on Canal Street, take a look. The marker just went up in December the 2024 to honor Louis A. Martinet. So that day when I'm out there, everyone out there with me from the Martinet family, they're white people. Now, why am I bringing that up? Because the book series is to teach you about the importance of advocacy, right? But Martinet could have opted out of this struggle. I mean, this man looked white in Reconstruction. This is the lynching era in Louisiana. And when you read these minutes, Louis and Martinet is saying, let's go start some agitation. Let's not accept this injustice. We cannot accept this. But this man is in the 1800s writing about the same thing we're here talking about today. Why won't you allow us to be free? Why won't you allow us to sit in that jury box and participate? We have a right to have a voice in the society we live in. So the book, hopefully at the end of chapter 1, you're convinced with the history that this is bigger than a jury box. This is bigger than the law to end non-unanimous juries. It's much deeper than that. This is a pathology. This is an embrace that we have been locked in as Louisiana citizens with this thing called racial supremacy. And this is a fight now to finally expose it and end it. So at the end of the book, I say what I have just done is the very first social audit in Louisiana's history. It is the first time someone has tried to look at all of the factors that define us as a society, the way we police, the way we interface with medicine, the way Black folks are treated in educational structures and in labor systems, how incarceration and profits are all intertwined. After I do that social audit, I reach 4 conclusions at the end of chapter 1, and I'm around page 86 as I speak now. One of those conclusions is, how do we get this way with our justice system? Is that the country itself never really understood what it meant when it said freedom. And if you don't really understand what you mean when you say freedom, you don't know where the people you freed are supposed to be. So we knew in chattel slavery, you should be on a plantation, right? That's where you belong when you're not free. But when you are free, where do we belong? Do we belong incarcerated? Do we belong in jury boxes? Do we belong in podiums like where I'm at today? We never really reconciled what we understood freedom to mean. That is one of our obstacles in achieving justice. The second obstacle that I mentioned in this is that we really have now is individuals who are practicing racism in the 1700s has morphed into now a system that is infected with racism. So we're dealing not with individual racists, but with systemic racism. Thirdly, I am saying to you that what we have built through this is a carceral state. And when most people think carceral state, you think numbers. How many prisons do we have? That is a flawed approach to understanding the carceral state, because the carceral state is much more complex than volume. The carceral state requires you obviously to assess volume. How big is our system? But the overlooked piece of this is that the carceral state also asks, do you understand how we got to the volume? So the carceral state is all about the mindset, the will to punish every single human transgression. So if you are houseless, the response in this country, punish you. If you don't have a belt in school, the response in this country is punish you. So our carceral state is about being punitive over things that some people don't even have control over, right? So we've built this carceral state and we're wedded to this idea that being punitive is the right response to everything. And the book challenges that. Lastly, the audit reveals that a jury and this non-unanimous jury conversation can never be seen in isolation. It has to be always analyzed for how it overlaps and intersects with other systems that maintain white supremacy and privilege. And so then we decide, now that we have understood what is wrong in chapter 1, and we understand why it is wrong in discussing those political rights in chapter 2, the question at the end of the book is, did it get any better over the years? And so I was hoping by the 3rd chapter to be able to say to you that, we have reached some improvements, but unfortunately, that is not the findings that I yield in chapter 3. So in chapter 3, what I ultimately end up noticing is that now the system has become one of bias. We had that before, that's not new. Racism, we had that before, that's not new. Caste supremacists, that's not new, but here's what's been added. Speed and the lack of any interest for anybody's personal stakes in their lives that are on the line in these systems when people confront with justice. So I describe it as being just void of any human concern. There is no humanity in the way that we administer justice now. And so when I get to chapter 3, I say to you that here's some of the problems that define our system in Louisiana. Cash bail, 140, on page 140. Our state's failure to properly fund our justice system is a tremendous problem, because what it does is incentivizes all of the fines and fees that now have to be passed on to people, and keeps a system running in the way it runs, because we can't end our dependence now on the finances that we get out of this. Page 141 talks about very long sentences that are unnecessary. And as I speak to you about the long sentences, I go into some of the specifics, habitual sentences, how we will take someone and say, this is your 3rd offense, so I'm gonna enhance the sentence. And in law school, when we hear that, we think that's proper because we think it's about public safety. We think that if you're getting an enhanced sentence, you must be a bad person. But what the book shows us is that sometimes the first charge was because I was hungry, so I stole a candy bar. And the second charge might be I was getting wet and I'm poor, so I stole an umbrella. And by the time you get to the 3rd charge, which is that I needed to get on a bus and I didn't have bus fare, so I jumped on the bus, the next thing you know, this person is a habitual offender doing a life sentence over a free ride on the bus. So the chapter profiles many of those cases and shows how our prosecutors are really overusing and abusing this habitual offender law, because that was never the intent. Another part of the book that nearly brought me to tears is, in all of this behavior that I saw, many of it was witnessed on records. So it wasn't like going on behind the scenes, but their lawyers who were standing up in the middle of the courtroom lying to judges, lying to defense attorneys, hiding evidence, being exposed on the record. And as I searched and searched, this was a 4-year journey for me with these books. I said, where are the judges who will address this? I just wanted to get some of those judges' dissents in that book to say, I needed to convince my law students that there are people in this judicial system who are there to do the right thing. And so I start looking, and I cannot find many dissents. I see Justice Burnett Johnson, her dissents are there, and all I'm doing is citing her dissents. And then I start seeing Judge Guidry, who just won the seat, and I can't sit here like I'm talking about a stranger in the back of the room, everybody. Judge Guidry, our Supreme Court Justice, who just got seated, was the 2nd and only judge in the state of Louisiana that I was able to cite in the book repeatedly. That does not suggest that no judge dissents. That was not my point. My point is I was only looking in the criminal world for dissent. I was looking for judges who were seeing these abuses in the criminal justice system. And these are the 2 that just jumped out, and there were just no others to compare. So I wanted to be able to find 30 or 40 to be able to cite, but it was a moment of grief for me. And then I said, I'm teaching law students, and some of my law students will be judges. So I'm writing the book for them to help them understand the power of you opening your mouth. Just you opening your mouth, not sitting anywhere. And I always say that it's important that you assess what power you have. Whatever power you have, that's the power you use. And one of the stories in book 3 that I tell about this is involving David Begnaud for CBS News. And so if you have book 3, you'll see the pictures to go along with the story. But remember, I'm talking right now about the judges in the state of Louisiana who are sitting in these criminal cases and watching prosecutorial misconduct, watching over-sentencing, watching official abuses of power, and who sit and say, I will go along to get along. For those people, I cite a story in book 3 about David Begnaud from CBS News, and I want to share this story because it's important that you understand the power and the importance of using whatever power you have. So CBS came down to Louisiana about 2 years ago when the state of Louisiana was going to issue a posthumous pardon to Homer Plessy, who you know existed in the 1800s and has long been deceased. So the CBS News crew was interviewing all of us who were involved with that process. And so when David Begnaud and the crew comes over to the house, we're sitting there talking, and David Begnaud says, well, Professor Bell, can you explain to the audience, why is this relevant? I mean, Homer Plessy's been dead since 1800s, right? And he's not gonna know that he's getting pardoned tomorrow. So why do you think this is significant? So then I say to David Begnaud, well, let me tell you why I think it's important. Because what the Plessy ruling did was so far reaching that I don't really think we've come to terms with that. We think it said you have to go sit in the back of a rail car. And we think it said that it is not constitutional to have separate but equal. But what I don't think we've understood is that Plessy seeped into libraries. So we couldn't read books if we were Black. And Plessy seeped into schools and educational systems. I really don't think, David Begnaud, people understood that Plessy seeped into the justice system. So when people enter courtrooms, they still see separate but equal to be legal because that's what the Plessy ruling said. And so David Begnaud says to me, can you prove what you just said? So I said, I'll give you a couple of cases off the top of my head. So I spoke about Kenny Zulu Whitmore, who is in the book, who's a man who's been exonerated through physical testing and who's still sitting in custody over 40-something years of his life taken because the prosecutors say before we'll admit that we've done this, we'll just keep causing dilatory proceedings. Mr. Whitmore's son and granddaughter's here, so if you don't mind standing for a second just to be acknowledged, I appreciate that. But this is a man over 40 years in custody who now we've had testing to show this man didn't do what he's accused of. And instead of releasing him, we just keep resetting court dates. 4 or 5 years have gone by since the last court date because that's easier than us acknowledging a wrong. So when I tell David Begnaud about Zulu's case, you all consider, I said, and there's another one here in Louisiana, Vincent Simmons. Vincent Simmons is a Black man, and 2 14-year-old girls said that they were raped. And the detective said, after they showed up 2 weeks later, by the way, the detective says, well, who did this to you? Describe him. Do you know his name? Small town, Marksville, Louisiana. These 2 white girls say, well, all N-words look alike. That's a quote. That's the description they gave to the officers. Those officers left the police station and picked up Vincent Simmons based on that description. And by the time I met Vincent Simmons had spent about 39 years over what was to be a 100-year sentence over these allegations. No physical evidence whatsoever. In fact, in one of those cases, the exam showed that there was no rape at all. And this man is doing that. So I was explaining to David Begnaud, to understand Vincent Simmons' case, you have to understand Plessy. You have to understand how Plessy conditioned people in the South to say that it's okay to put them in the back because they're different. It's okay not to treat them like us because they're different. In fact, the Supreme Court said that it's totally legal. So when Vincent Simmons shows up for trial and there's an all-white jury, they don't think that he's deserving of the proceedings that a white man would get, so they gave him Plessy justice. So when the cameras go off, this is what David Begnaud said to me. Professor Bell, I've never met anybody with the passion that you do for justice, and I'm not calling you a liar, so don't be offended, but I don't believe what you said. I think there's more to the story. There's something you don't know. So I said, it's okay for you to call me a liar because tomorrow, if you take me up on my offer, you're going to call me back to apologize. My offer, David Begnaud, is that you read what I'm gonna send you. So the producers are there. I said, I'm swearing everybody under oath. I'm gonna send you this. I want somebody to call me back tomorrow and tell me that David Begnaud acknowledged that he was wrong. The next morning, the producer, Sean, calls and he says, Professor Bell, I'm not gonna say a word. We're gonna get David Begnaud on the phone. David Begnaud says, Professor Bell, he said, I have been up all night. Normally, I have my producers read stuff, but I was so determined to prove you wrong that I read all of this myself. He's crying as he's speaking to me. He says, I not only owe you an apology, but I cannot allow this to happen and me do nothing. David Begnaud goes to Marksville, Louisiana, and tells that prosecutor that I am getting ready to run a story. And all I want you to do is get on camera and tell me how you justify this. About 3 weeks later, I get a call, all of this documented in the book with photos from the producer saying, Professor Bell, what time can you be in Marksville tomorrow? The crew wants to catch you walking in the building for the story that we're gonna do. So we agreed on a time. I get there and I'm walking in the building and Vincent Simmons goes home. Walks out of a life sentence, not because of a lawyer. Now, if you see the story on the news, you're gonna see a guy jump up and say how he's Vincent Simmons' lawyer and all that. We know how that works in the legal law, right? But Vincent Simmons walked out that day. And the reason I'm telling you the story is not because of me and anything I did, but because of David Begnaud, the non-lawyer, who said the only power that I have, don't know how to practice law, but I know how to use a microphone. I know how to use my skills to try to make sure I investigate. And I know how to hold people accountable. Walked in there and was willing to put it on the CBS News, which, by the way, he did. I want you to understand that that is what I'm asking in the books that we do. The 14-year-old Black girl, Aretha Castle Haley, the Maroons, whatever the little power you got. So when I was reading about these judges, I started wondering, do they understand when people elect them, they're the only power that we have. We don't have any power. Once we elect you, we think you doing it. We ain't there to do it. We trust you. And I can only get two that I thought I could document. Again, I don't suggest nobody else writes dissents. I'm only saying I'm looking strictly in criminal. And I felt like for all the criminal violations that exist in Louisiana, I should have been able to cite more than two judges. All right. I go on in the book to talk about page 145, this notion now that we have lifetime parole. And some people say, well, that's probably necessary because some people do bad things and they need to be monitored for life. And I don't disagree. What I do disagree with, however, is the reckless way it is being used in Louisiana. The way you will take a person like Mr. Lloyd Jarrow, who I speak of in the book, and Lloyd is here, if you don't mind, Lloyd, if you'll stand for a brief second. But you take a person like Lloyd, who was convicted as a young person, 16-year-old, and tell him, sign the paper, I'll give you parole, and he's signing papers, don't even know what he's signing because he's been in 20 years. He just want to go home. He's a victim of the system. He can't get justice no matter how many times he files stuff. So he's signing papers, and then he gets to the first day at the parole office, and they tell him, you know, you got to pay us for the rest of your life, right? But that's not Lloyd's only problem. If Lloyd wants to go out of town for the weekend, Lloyd has to continue for the rest of his life to call a parole officer to get permission. If Lloyd wants to have a date, he has to be always waiting on somebody to come knock on the door saying, I'm here for your monthly parole check. Lloyd and I have been in public places doing this kind of work all over the state of Louisiana. He is no threat to anyone. He does not deserve this. He should not be under that kind of supervision, but there's no instrument to vet who is the right candidate, because when you don't see people as being equal to you, anything's good enough for them. So the book speaks about that. The book also talks about legislators who've lied to people over the years, like the 10-6 lifers who agreed that they would take pleas in exchange for getting out in 10 years, and they remain behind bars 30, 40, 50 years later, and there's no accountability to anybody for that. Then also talk in the book about the folks who are convicted by non-unanimous juries. Those people who, when you read Louisiana Supreme Court's ruling, as well now as the US Supreme Court ruling, says that what Louisiana was doing when it used these non-unanimous juries was an assault on the Sixth Amendment. The Supreme Court of the United States said that those juries were so unreliable that any person that was tried by one of those juries is almost like you never got a trial at all. However, there's over 1,000 men and women who's sitting right now in Louisiana because the law was not retroactive, so they never got out. And so we're saying to those people, your life doesn't mean anything, because remember, freedom, we didn't understand really what that meant. So you're not free. It doesn't matter to us because we feel like you didn't deserve it in the first place. So these people, you got convicted. Somebody on the jury said there's reasonable doubt, but we don't care. Oregon cared. It took care of its folks and corrected its injustice and owned up to it, by the way, called it racism on paper. In fact, the book that on book 3, I described white supremacy. It's the best description I've ever seen in my life, and I got it from Oregon in its Supreme Court decision that ended 9 unanimous juries. That's how honest Oregon was. It dealt with it. It's over now. Louisiana's telling these people, sit here, give us your life, although we didn't give you a process that you were truly deserving of. So that also is something that comes out in the book. And then I, in the book, talk about the rates of plea bargains here in Louisiana, astronomical. And when we use non-unanimous juries, that was one of the big contributors, because people were so petrified of a jury in Louisiana that they would rather plead to something they didn't do to know that they at least could get back out. So we incentivized a lot of people to take those pleas. And when we undid these non-unanimous juries, it didn't do anything about those folks who took pleas. But then we also just have a culture of lawyering here in the state where it's easier for me to get you to take a plea than it is for me to prepare for court. It's easier for me to get you to take a plea than it is for me to file a couple of motions, because I want to go to Mardi Gras. So I'm not willing to sit and grind and work behind the scenes. So I'll just do something quick and sell you away. That is also a culture of lawyering that I'm seeing also in the book. The book talks about prosecutorial misconduct, not misconduct like I made a mistake, not misconduct like I forgot, misconduct like I didn't care, that I knew I had the wrong person and still took this person to trial. I speak of in the book at the end of it, I said, if anybody is concerned about victims, because people kept saying to me, when you're writing this book, think about victims. Always remember crime victims, which I have been myself. So certainly I'm sensitive to that. But in the book, I even was able to profile a case where there's a guy who all of his victims are now women in college who gave affidavits to say that what this guy did, us sending nude pictures back and forth to each other, it was not him violating us. We weren't victims. All the state is calling us victims. We ain't no victims. We were doing this with him. We were sending him nude photos and we was enjoying his nude stuff back. That, by the way, is at the end of the book. And I have his sister here now, if you don't mind, Stan, Miss King. This is actually Attorney King, by the way, who came to law school because of her brother Styles, who I end up featuring in the book. So I appreciate you being here to represent your brother, who, by the way, you know, is a white boy. And I wanted to be sure that we all knew that, because in the book, I wanted to make sure I included in the story, this is not a justice system that just harms Black folks. This is a justice system that will harm anybody. And there are many cases of white people in the book who have been on the receiving end of injustice as well. And so I wanted to be sure that that was accurately told. The book also talks about page 167, Shelley Davis, who is sitting and doing a life sentence simply because prosecutors decided, I want to convict this woman. And the way I'm going to do this is I'm going to go on her social media and I'm going to get things off her social media that she might have posted when she was 13, 18, 22, doesn't matter. It had nothing to do with the crime, but I'm going to show the jury the lyrics. And so one of the things that I learned in talking to Shelley and a lot of the folks in Shelley's age group is that they would listen to a rap song and they like these lyrics and they post the lyrics on their social media. And then the prosecutors are now using those rap lyrics or using social media posts, and it's inflammatory to an all-white jury who doesn't understand rap culture or gangster rap. So they see this Black woman throwing up this gang sign and some vulgar language, and boom, here's Shelley Davis doing a life sentence that she really doesn't deserve. The book talks about that. And then the book also talks about all of the people who have joined me in this fight. And I have two of those people that I want to recognize today. If you don't mind, I call them the twins, because I can never figure out which is which, but you all, if you don't mind, stand up for a second. But these two ladies are not in any way connected to Louisiana's legal system and have now become part of my family through the journey that we're all collectively on. But one of them had the misfortune of being summoned in to a court proceeding. And as she describes it, and I speak of it in the book, it is almost like you have now involved her in a criminal syndicate. Because when you send a person a subpoena and say you have to come to court, they're being forced now into criminal activity with you. And you're a prosecutor and you're lying, and I'm involved in the lies that you're telling. I'm now in a criminal syndicate. And so they were so disgruntled about what they witnessed in the name of justice that they actually went on a crusade to try to fight a conviction that they helped to cause, because they relied on information that they were told and later discovered information that they were not told, and realized that had they been told the whole story, they would have never participated in this. But through their own personal funds, the book speaks of how they wrote over 5,000 letters trying to stop a conviction of a person that they felt responsible for participating in. This is the kind of thing when I say, whatever power you got, this is all the power I have, I use it. And so here are two people at no connection to Louisiana's legal system who are now invested in this fight to improve and change our justice system. And so the book ultimately ends by helping us understand that it is the duty of anyone in a democracy to be a part of making upgrades and changes. It's a duty of lawyers, obviously, to enhance the profession. But the duty is heightened in a place like Louisiana because we're not a common law jurisdiction, we're a civil law jurisdiction. And as civilians, the entire design is that you are making the legislature aware of the things that you want and the things that you don't want. So there should be a relationship in a civil law jurisdiction between citizens and legislators, and that I find to be absent often. So what I did in the last book was also put together a how-to. How do I walk into the legislature and speak and talk and get changes done? How do I communicate with legislative members if I don't want to physically be present to do it? How can I do it alternatively? And the other thing I want to say before I close is a lot of what I have done was never taught to me in law school, particularly in the policy arena. So it was important to me in book 3 to teach people that policy is perhaps more important than law. And I want to explain to you why I say this. When Donald Trump took office in 2025, he started immediately issuing out these executive orders. And people are reacting like, wow, look at all of this stuff. But there's a backstory to that. And the backstory to that is that there's some citizens in the 1980s who just didn't really like the way the country was developing. They really didn't like the idea that women were having abortions, and they didn't like the idea that we were having a bunch of immigrants and achieving a lot of diversity. That was unsettling to that group of people. That group of people organized, and amongst the group, they said, what we'll do is create a manual, and we're gonna give this manual to each president, and this is gonna be the manual of how to take the country back. And so there's a chapter, Women and Reproductive Rights, and they literally write out all of the executive orders and all of the laws that they want the president to enact. They started doing this with George Bush, and they formed a love affair with George Bush, and he started employing them. They tried it again with Obama, didn't work so well, and then they kept on going because they were determined. Remember what I said about using the power that you have. So they use the power they have. This group I call the Heritage Foundation. And with every president that comes in, they say, we will help you get elected if you ultimately let us run the office. So the Heritage Foundation has a book that Donald Trump got before he got elected, and all the stuff that everybody's seen and reacted to, that was written by them. Now, what's the point of this? The point is that there is something called policy that law schools don't teach. But policy is the conscience of the people. It's the level of tolerance that the people have for a certain thing. So if we don't like women getting abortion, we want to, that's the policy, that's the feeling, right? A law normally follows policy. So laws are, policy is the inspiration for law. And one of the examples I give in the book, if you live in a subdivision and you have ducks, and you like the ducks to be able to walk around. You don't want them killed. You see people riding through the subdivision in a race, they could kill your ducks, right? So the policy is the idea that I want to protect the ducks. So I go out based on the policy and I put speed bumps. But I also want to punish anybody who won't comply with my policy. So then I go get a law. You get it? So when we're working for 3 years about law, what I'm helping you understand is law is the symptom of the disease. The disease is the focus that I am trying to get you to think about in the book. So by the time you got a law, it's too late. So all of us need to start thinking as lawyers and non-lawyers alike, what policies do I want to see happen? And so the book teaches you how to find policy if it exists. If it doesn't exist, how to go about crafting policy. The main thing about policy is to understand that policy is just based on what you're willing to tolerate, what you like, what you don't like. So if you're not in the room, if you're not in the conversation, if you're not in the area of influence, you can't affect it. So the book is about not just arming yourself with law, but understanding the importance of policy. And then finally, the book also says lawyers and non-lawyers always rush to see a law. How do I fight it with a law? The book discourages that, and the book says that you step back and first of all realize that we're not just in the United States and we're not just in Louisiana, we're part of a global community. So the book talks about using international law as well. And interestingly, just last week, I was teaching in my criminal procedure class about habeas relief. And I had an application for habeas relief so they could see how it looks. And I had them read the application and it says, which law are you filing under? But it didn't stop there. It says also which treaty. So the habeas applications actually recognize that we're part of a global family, not just a state or a federal. So you always remember that sometimes if I don't like what I'm seeing and I'm fighting locally and I'm not getting anywhere, and I'm fighting federally, I'm not getting anywhere, there is also an international fight to be had. And so the book trains you to understand that you need to be aware of treaties, and you need to be aware of how to fight internationally. And the place to go if you're ever interested in finding if we are signed on to a treaty is the State Department. The US State Department has a list of all our treaties. And one way that I've used this practically, I want to share, if you all remember the 70s with Angela Davis and the Afro and the raised fist, that era, out of that era comes the Soledad brothers case, which is a famous case out of California. But ultimately, these guys were accused of killing a guard. And the guard was killed at a day where one of the Soledad brothers was not even on the tier. How do I know that? Because I was able to get him to give me the authority to get his prison records. Once I got the prison records, the records exonerated him. So I didn't really have to do anything brilliant because the records show that on this day that guard was murdered, he was visiting his mother in that building. So I'm trying to understand, why is he even here if the records show this? Well, fast forward, the governor of California wrote a statement saying that the parole board is willing to parole him, and California's parole board is a lot of law enforcement officers. So to get unanimous parole in California is a tremendous statement, and they were ready to cut him loose. The problem is the governor wouldn't sign off on it. And the governor did us a really, 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 really big favor. He wrote his reasons. And his reasons basically said, I paraphrase, but I'm not going to sign off on this because back in the 70s, you killed a guard and the jury wouldn't convict you. So because they didn't convict you, I'm going to hold you here. Now, we know that to be ex post facto, right? Thankfully for us, he did that in writing. So I had a group of law students and I said, well, here's a lawyer already. Let the lawyer do what lawyers do. Let us do something in a different lane. Let's stay out of his way. So we went the international route. And we wound up filing under a treaty that involved due process, elderly rights, and all of that. And the end of the story is the California lawyer called and said, do not allow your law students to know this. It has to be maintained in the strictest of confidence. But what ended up happening, he was fighting in court and we were fighting internationally, but the international folks sent a letter of inquiry to California and said, we would just like you to explain this. Now, it happened at a time where the governor of California was in a feud with the president. And so here is the international community trying to ask you to explain what you can't get support from because the president won't back you, right? So the governor knew the best thing to do was just end this. So the call was that the State Department is going to arrange for him to come out, but there will be no media and no one is to know. So it is 3:07 a.m. A van pulls up and takes him out, and he's now free. And that is the pressure that was built between all of those forces. So and this is an 80-year-old man who had overdone 40 years already. So I'm making sure in the book that you understand that sometimes it's not law, sometimes it's advocacy, and sometimes it's strategizing. And the last story I want to say to you before I end, and my husband always says you say that 5 times before you end, so I think that was the 5th time. So that means I'm really gonna end. But the last story I want to tell you, when I went in for my very first visit with Herman Wallace, who is now deceased, but he's one of the former members of the Angola Three. And Herman is the one of the three. If you knew them, Herman was the one that would inspire the most fear. Not because he was a violent man, but because he was a fearless man. And Herman was gonna fight and fight and fight until he won. And so of the three, the one the prison really wanted was Herman. It really wasn't Albert and King. So I go in to visit Herman for the first time, knowing his reputation. Herman is in solitary confinement. So Herman comes out, his hands are shackled, his feet are shackled. That's the way they are transported. And here's this guy coming out trying to shuffle to get to see me. And before we sit, I'm ready to sit. I'm thinking he wants to sit. He says, no, don't sit. I have a question. And I said, yeah, I'm thinking, well, what is it? I'm just meeting you for the first time. He said, are you a leader? And it was just a strange way to meet a person. I was like, just at a loss for words. And he said, are you a revolutionary? So I said, I don't know. Let's sit down. I'm just meeting you. I'm Professor Bell. How you doing? I won't talk about that stuff. Let's talk about that later. I don't know. So he said, well, this is why I'm asking. He said, I don't want you to sit down, and I don't want to sit down with you if you're a leader. And he said, a leader is a person that wants a photo op. They happy if they get a picture in the paper. They happy if they get a victory, and then they gone. A revolutionary is a person that is fighting for the next generation. They're long distance runners. They may never get the picture in the paper. They're relentless. They understand sometimes victory has to ferment. And I only want you to sit if you're going to be a revolutionary. If you're a leader, don't come back. Now, this is a man on doing 40-some years in solitary confinement who needed help from every direction possible and taught me one of the most profound lessons of my life. So I end by making sure that as I tell you all of these things I found and all of the fights that I want us to have, none of it is fast. All of it is slow moving. So if you're going to get involved with this, try to understand their risk to it. And you have to be willing to accept that sometimes what you're doing is not even for self. So it is really the work of trying to lay the foundation for the next generation. All right. So I'm going to pause now, and I think we have about 10 minutes for Q&A or comments or anything that you feel inspired to share. So feel free, and I'm going to also start checking the chat. I'm listening on the front row.
How you doing, Professor Bill?
Hi.
David Chapman, first year law student, Southern University Law Center. First of all, thank you for sharing. Very insightful. I got a couple questions. I guess I'll start off with this one. In either of your books or just throughout your research, have you had a chance to have any findings regarding why this particular demographic is just so gun-ho on us not having power, regardless of us being in 2025? Like you mentioned that we've made progress, but a lot of these things seem like they're about to be repealed with all these executive orders and whatnot that's been sent out by the president. That's my last question would be, how can law students and just common people still advocate and be engaged in a fight amid all this?
So one of the things that I hope to have you understand is what is the undercurrent in all of this is just textbook supremacy, okay? You will never stop that. I also discourage reacting to anything anybody does. So when I see the executive orders and I see the Heritage Foundation, I'm gonna say something that's gonna seem strange, but it's inspiring to me because I'm a person that likes to see people do it, right? And it inspires me. What troubles me is that we wait for somebody to do it and then we fight back. They don't wait for us. When they were writing those books, they weren't waiting on anybody. They had a vision, they did it. So my response is this: if a person wants to practice supremacy, we do have a country that allows for that, right? Let them do it. But you should be simultaneously doing what you do. Because if you do what you do well enough, that person is nervous doing that around you, right? So where I exist is I want to make people nervous and uncomfortable doing anything that is going to be oppressive to anybody. So I don't fight for a group, I fight for justice in generic sense. So anybody who is doing anything that is oppressive, they should be uncomfortable around you. And you should already be thinking about what it is you want to do. And so one of the things the book talks about is visioning. Visioning is the first skill of an advocate. Most people think as an advocate, the first thing I do is I grab a pen, I start writing, right? Or I grab something, I start filing. No, you actually sit down and get in your head. And your vision is not just what you want to tear down, but what you want to replace it with. So as an advocate, what is my vision? And while that person is doing their supremacy stuff, you should be doing your vision. You shouldn't even be distracted by them doing what they do. You should be doing your vision to where you have them now distracted and nervous around you and not the other way around. Do you see my point? And if you're in law school, you have to realize law school is going to want all of you, not some of you. Do you get what I mean? You have a wife or a spouse. Let me tell you a secret here, because I've been married over 30 years. My husband will tell you, I don't want a piece of him. I want all of him.
All right.
So law school is not going to allow you to do a whole lot right now. So what you can do best is be the best possibly trained lawyer you can be, and then seasons. In your season, you do your part. All right? Anybody else? Comments, questions? And if you're on Zoom, feel free to just jump in, unmute your mic, and you can jump in as well. Any questions, comments? Yes.
Just have a, I guess it's comment point question when we were talking about the jurors, non-unanimous jurors and the influence or role that they play in racism and all of that. I was just, when you were talking, I was thinking about Medgar Evers' trial. When it wasn't a jury trial, it was the judge that was going to hand down the sentence, and the governor of Mississippi came in and sat behind him, behind Beckwith.
Yes.
Sat behind him and rubbed on him back and told him that it was going to be okay. And that put the system, at a test.
Yes.
And also challenged that judge, his livelihood, his future,
Of course,
or whatever, to change that, even though he was guilty as hell, we all know.
Right.
Just that political influence, we were talking about politics and stuff like that, but that is still playing a heavy role in our sentencing and in our efforts to try to, in all of this
Yes.
imbalance, racism or prejudice that gets these crazy sentences,
Yes.
stuff like that. So even we're talking about the jury, we still have to worry about that political aspect. And I'm just asking for strategies, or how do we do that? Do we just still observe that? And like you say, we still keep our vision, so when they do that, we're able to respond to it?
Well, one of the things that I find the lawyers that really fight this well are activist lawyers. So, you know, the question is, are we training activist lawyers? Or are we training lawyers who learn to be political, which has been my observation, and not seeing us being activist lawyers, but that's a special training for that, to have a lawyer that understands that you want to fight. And so what I found a lot in this state is our activist lawyers, they are not socialized in Louisiana. And I'll give you one great example. One of the lawyers that I cite here a lot in the book who challenges a lot of this stuff, his name is Richard Bourke, B-O-U-R-K-E. He's the director of Louisiana's Capital Assistance Center. He fights hard when it comes to juries and any type of racial issues on juries, but he's from Australia. Do you see what I mean? And what is importance of that? Because in the South, a lot of times people of color have been socialized that you don't stand up. That you have to, because of our history here, that you have to be accepting, you have to be patient, you have to be prayerful, right? And so a lot of times when we have those activist lawyers, they're not locals. Another thing about that jury box, there's two trials that I want to mention to you. One in the book I cite in book 2, to test everything that I've said to you about the importance of a jury and how I know they work. Book 2 focuses on one of the most controversial trials we've had in the state, and it is the trial involving Louisiana's Black Panthers. They were in their headquarters in September of 1970. Orleans Parish Police Department comes in, guns blazing, and starts spraying and shooting these folks up, take them out, the ones who are not dead, and bring them straight to death row. Listen to the charges. All of those Panthers were charged with attempted murder on the police. I hope you just heard what I said. Now they're inside their house. The only reason they survived, they were all militarily trained before they became Panthers. So these are former veterans. The only reason they survived is that they had been trained from headquarters in California, all of them around the country, to always have the walls covered with sandbags. So because of that training, that's what spared their lives. Now they're sitting on death row for over a year. And what's the first obstacle here in Louisiana? What's the challenge? What do y'all think is the first problem for them? What's the problem? They can't find a lawyer. So they end up getting a lawyer who is trained at Howard. Most of these cases from this era you will see being fought by Howard lawyers, and they partner with Louis Eli, who is a local lawyer. My book also mentions Richard Sobel, who is a legend in Louisiana at this point. This is a white man from up north, by the way, who comes, again, not from our social conditioning. Ernest Jones goes to trial, but Ernest Jones said something really important to me as I wrote the book. Ernest Jones said that I knew that I was not representing anybody who had attempted murder on the police. In fact, I wasn't even representing something involving New Orleans and Louisiana. This was a political prosecution. And he said the way you fight a political prosecution is with the jury. Ernest Jones said that he took more time selecting the jury than the trial lasted itself. Interestingly, right after I interviewed Ernest Jones for the book, I wound up meeting some of the lawyers for Huey Newton, who also wrote a book. And guess what those lawyers told me? They knew that they could get Huey Newton off if they could get the right jury. Because you're fighting a political prosecution, and what you need is the people who understand political oppression. So Ernest Jones gets a diverse jury. That is important. Remember what I said earlier about the viewpoints and all of that? The diverse jury listens to this case. There's some white people, some Black people, some old, some young, some people from Louisiana, some not. Guess what they do? September 15, 1970 is when this ambush happened. A year later, that jury said not guilty on every single count. And every one of those Black Panther members are free people as a result of those juries. Scared the state so bad that when they tried to have a second trial over a second ambush, they decided to offer them plea bargains and drop the charges before they would go to another trial. So my answer to you is, a part of the fight is understanding as a lawyer what you're capable of winning, and understanding what the people have to step up to help you do to finish the job. Because it was the people being willing to serve in the jury box that day that ended up causing those Panthers to see freedom. Finally, I want to say, and the book addresses this, to people of color, are people who are justice-minded as well. When you are asked to come in for jury service, understand the necessity of you being there, because your ability to reason and analyze and think is going to possibly shift those conversations in that room. So another motivation with the books is just to get to people of color or people who are justice-minded, to help them understand that when you get that notice for jury service, and yes, that's something you can do, right? Be there and not just sit there. Be there and be present. Because sometimes we can get in a place and don't know how to use the power we have, right? So if you're sitting there, it's important that you speak up. Any other questions or comments? Nothing else? All right, yes, sir.
You mentioned the importance of policy and how it can be more important than law. So what are some ways that we as people can just get better at interpreting policy and moving the needle to change policy to make sure it actually reflects what the people want in society?
So the specific ways are outlined in book 3, but some of the things that you'll learn is that when the policy sometimes is written, which is the ideal thing for you. If you want to know policy, sometimes it's written. So you look at a law, and some laws will literally say the policy of the state of Louisiana is, so you know what it is, right? But another way you can find policy, and I relied a lot on some of our local experts with policy, so I'm quoting some of what they taught me about policy, and that is sometimes just sitting in school board meetings, sometimes sitting in your local meetings, and you see what the policy is through those things that are being put on that agenda and being decided. Sometimes the policy comes in the form of executive orders from the governor or from the president, right? Sometimes the policy is set inside the prosecutorial's annual meeting, when they meet annually. Judges meet annually, lawyers meet annually. So sometimes it's in those bodies, those local body meetings, is where there's policy. But as far as changing policy, it's when somebody's already got a view and you want to counter their view. How do you do that? So some of the ways that I've done that is with solitary confinement. I didn't want to see that continue. So what did I do? One of my partnerships was with an artist. And you'll see in the book footage of when this issue came up in the United States Congress. One of the things that we decided to do was to change policy. Is we wanted the members of Congress to actually stay inside of that cell. So that artist constructed a 6x9 cell and got permission to bring it into the US Congress. And I put the photo in the book just so you can see it. But when I did this work, and in my office right now upstairs, I took personally a box, like when somebody delivers a big refrigerator, I took that box and cut it into 6x9, and I have it in portable form. So anywhere we'll go talk, here I go lugging this trash bag full of a cell. But I would say to people, you know, when I'm talking, I want you to actually get up, and I want you to stand here, walk in this. I want you to walk in here. I want you to see, like, this is 6x9. This is how it feels. I want you to pretend there's walls that you can't get out. I want you to understand you don't talk to anybody. This is where you're going to eat. When I would do that and have people get in a little box that I cut out, you know, no, I didn't pay any money for the box. I would see grown people start weeping. And I would see people start, you know, shaking, like, this is what this feels like. Now, I wasn't doing that to torture people. I was doing that to create something called empathy. And once people have empathy, policy begins to be easy. Do you see what I mean? So how do I get you to enter this world that is unfamiliar? That is the work of you being creative as an advocate. All right. Any other questions, comments? I think it's probably lunchtime now, huh? All right. Well, thank you all for everything. I appreciate it. Make sure you have an address on file if you want the books. And if you're on Zoom, make sure your address goes also to Vice Chancellor. And thank you, everyone.